Estate planning essentials: wills, durable power of attorney, healthcare proxy, living will, revocable living trust, letter of intent, important documents, and limited liability company. These are all potentially important documents for your estate plan. The one that's pretty universal is the will. It's a fundamental element of an estate plan. It's a legal document that outlines who will inherit your assets, stocks, including stocks, art, investments, and personal belongings upon death. Without a will, one's assets are distributed according to state laws, which may not align with your personal preferences. Even if you don't have kids, you should draft a will so your assets are transferred according to your wishes. If you don't have a will, the state's intestate law will determine where many of your possessions and assets go. When I ask my clients if they have a will and they say no, I reply, I've got good news and I've got bad news. Good news is you do have a will, and the bad news is the state of wherever you live has written it for you. And it can have some unpleasant consequences. I'm told that in the state of New York, for instance, suppose you have a spouse that owns a house and then they get married and you don't add the new spouse to the home's title. Then you have children. If later on the spouse who owns the house doesn't have a will and they die, this could potentially be problematic for the surviving spouse. As I understand it in New York, when there's no will, the surviving spouse will be entitled to $50,000 and will have to split the rest of the assets passed by will to the children, with the children. Any one of these children could force the surviving spouse to come up with the cash or maybe sell the house and give up their share. Keep in mind, there are certain assets that will ignore what's put in the will. Examples include life insurance, annuities, retirement accounts, and accounts with a transfer on death or equivalent designation. These are particularly important to review if you have a change in marital status. And this document does not take effect until you are dead. Power of attorney. This legal document grants a trusted individual the authority to manage your financial affairs in the event of incapacity. It'll live as long as you do. Once you're dead, it's no longer effective. This is a critical document I urge my clients to seriously consider. Recently, I had a client who put a power of attorney on his accounts with me. Years after he did this, just shy of the age of 64, came to my attention they had early Alzheimer's. When I contacted my supervision, they said, yeah, you can't take instructions from this person anymore. But because this person had taken my advice and put a power of attorney on the account, I could call the power of attorney and take directions from them. Without this simple step, the family would have had a more difficult time accessing funds for their care. Healthcare proxy, also known as the healthcare power of attorney. This document appoints someone to make medical decisions on the behalf of the individual in the event they're unable to do so. Remember when I was talking about the power of attorney enabling someone to do your financial affairs? Well, it doesn't cover your medical affairs. You need a special second document in most cases to do that. Living will. This outlines your preferences for end-of-life care. It provides guidance to healthcare proxies and medical professionals regarding care and wishes related to life-prolonging treatments. Now, there's a case study, the Terry Schiavo case, an instance where a living will would have been helpful. Terry Schiavo, at age 26 in 1990, she went into cardiac arrest and a few months later was determined to be in a persistent vegetative state. Her husband argued she would not have wanted to live like this and wanted her feeding tube removed. Her parents disagreed, and there was an extensive legal battle. She passed in 2005, 15 years later. This document could have prevented or at least made this simpler to handle. Revocable living trust. Revocable living trust transfers assets into a trust during your lifetime. Upon death, these assets transfer to the designated beneficiaries without going through the probate process. Generally speaking, unlike the power of attorney and the will and the healthcare proxy, which are effective for either the time where you're not alive or the time where you are alive, this one straddles that. So probate, just for folks who don't know, it's a process where the court approves of the disbursement of assets. So when they bring the will in, the courts says, yeah, you can hand it off to these people, but it's a public process and people can come in and say, no, no, I am the rightful heir, and it can be a big fight. With the trust, as I understand it, it's not public and they don't get to contest it, or at least if they do, it's much harder. Another instance where a revocable living trust might be a good idea is if you own property in more than one state, because your heirs could end up having to do what's called ancillary probate, and I'm told that's a real pain in the neck. Letter of intent. It's not necessarily a legal document, but it communicates what you would want to happen after your death or incapacitation. It can detail funeral arrangements or provide information for the person managing the affairs. And this can help your heirs avoid a lot of stress at what's going to be a really stressful time anyway. And important documents. It's an organized list of necessary documents such as birth certificates, deeds, military discharge papers, and insurance policies. And their locations can significantly assist loved ones in managing the individual affairs after death. Military discharge papers, because I am a veteran, I focus on a little bit because they're important, even if the surviving spouse was not a veteran, because they may be entitled to benefits even after the passing of the veteran. Limited liability company can be integral to an estate plan, particularly if the owner owns a business or substantial real estate. It can help protect against personal liability for business debts and claims it offers additional tax advantages. It can survive the death of the owner depending on how it's set up. Estate plan should encompass all assets that an individual owns, range from financial assets such as stocks and real estate to tangible assets like art, cars, and other personal belongings. It's vital to include the jointly owned assets in the estate plan. Consult a financial professional and an attorney for guidance on how these assets should be titled and other related matters. In conclusion, whether you're single, without children or not, it's essential to have an estate plan so your assets transfer to those you wish. Enlisting the assistance of financial, legal, and tax professionals in estate planning can make the asset transfer process smooth and less stressful for family members and people you care about. I once had a client who was very organized and had good files. The couple had reached the stage where they could no longer care for themselves. The children approached me to help sort their parents' affairs out. They had little idea what was what. I was able to help, but had the clients organized specifically with the idea they'd not be able to help one day. The family would have not had to go to the expense of having someone figure it out. Part of what I offer is helping people organize ahead of time and making things easier on their heirs when the time comes. Where a financial planner like me can help. I can't produce legal documents, but I can spot gaps in a plan. An attorney is required to consult and generate the appropriate documents. Part of a good financial plan involves getting the assets where the owners want after their passing. One of my favorite quotes, those who fail to plan to fail. This is not legal advice. Consult an attorney before taking legal steps. Once you graduate, be it from welding school, engineering school, or law school, you're going to need a different plan for each of these stages that's tailored to your individual situation. In your working years, biggest important question, I think, is, am I saving enough and is it in the right place? Your path to retirement, glide path to retirement, which I define as the last 10 years to retirement. Will the USS retirement be shipshape on the appointed day? And in retirement, how do I avoid running out of money before I run out of life? And finally, the legacy stage. Does what I worked hard for get to where I want it to after I'm done with retirement? Can be reached at herwirefinancial.com. I do in-person, Zoom, and phone appointments. I am licensed and registered across several states and can easily add states if there's a need. If you'd like to schedule an appointment, you can click on the schedule an appointment button in the upper right-hand corner of my website. Want to see more videos like this? Go to my website and click on the YouTube channel button. It's that red one between the LinkedIn and the Facebook links. Please like and subscribe. Those who prefer the good old-fashioned telephone, my number is 518-631-2569. Do not text that number. We'll both be sad as I won't get it. There's a separate texting number there. Opinions voiced in this material are for general information only, not intended to provide specific advice or recommendations for any individual.